Supreme Court's interim order on Waqf. No blanket stay, but key Waqf provisions frozen. Waqf legal battle far from over. Decoding Supreme Court's interim order on NewsTrack.
Good evening, this is the NewsTrack and I'm Marya, Shakil. The Supreme Court has delivered a significant ruling on the Waqf Act. Though it declined to stay the entire law, but put on hold three key provisions, including one, requiring potential donors to be practicing Muslims for 5 years. While both the sides are claiming victory after the interim order, the question remains, what does this order really mean and who truly benefits from it? We'll try and decode that on NewsTrack with our top guests joining me shortly. Waqf JPC Chief Jagdambika Pal will be joining us. We also have top Supreme Court lawyer and Congress MP Dr. Abhishek Singhvi will be joining me shortly. But first up, here's what happened today.
In a significant development, the Supreme Court has refused to stay the Waqf Amendment Act 2025 in its entirety, but stepped in to freeze key provisions seen as controversial and constitutionally sensitive. The court put on hold the provision that a person should be practicing Islam for 5 years as per Section 3R to create a Waqf. It said that the provision will be stayed till rules are framed on determining whether a person is a practitioner of Islam. The apex court further stayed a provision which empowered the collector to determine whether a property declared as Waqf is government property and pass orders. The CJI-led branch also said that permitting an executive officer or collector to adjudicate property rights violates the separation of powers, and it has put a bar on changing revenue records. The court held that the Central Waqf Council shall not consist of more than 4 non-Muslim members and a state Waqf board not more than 3. The court directed that ex officio officers in Waqf boards must be from the Muslim community. While the opposition welcomed the Supreme Court's interim order on the Waqf Amendment Act 2025, the BJP claimed it a positive development.
हम उम्मीद करते हैं कि सुप्रीम कोर्ट जल्द से जल्द एक फाइनल डिसीजन लेने के लिए जो भी जरूरी इक़दामात करना है वो सुप्रीम कोर्ट करे।
एक तरीके से पार्लियामेंट ऑफ इंडिया का जो डिसीजन है उसको कायम रखा। एक जो प्रैक्टिसिंग मुस्लिम का जो मामला है उसको हम लोग देखेंगे।
With the Supreme Court's interim order, the fate of several provisions in the Waqf Act 2025 now hinges on further hearings and the centre's framing of clear rules. The matter will now return to the court for a final decision, but for now, the battle over the Waqf law is far from over. Bureau Report, India Today.
India's top legal Dr. Abhishek Singhvi joins us. He's a senior counsel, 4th term MP, and also chair of several Parliament's standing committee. Dr. Singhvi, I appreciate your time. The Supreme Court in today's judgment has expressed, and I'm quoting, sir, in the totality of the circumstances, we do not find that any case is made out to stay the provisions of the entire statute. Given that the petitioners were seeking a total stay on this act, is this a setback?
I'm glad, Marya, that you started with this question. It's been running across the news cycle since afternoon and in the evening in several of the channels. I am frankly quite astonished. It betrays a delightful, happy, blissful ignorance of law, principle, and of what happened in court. First and foremost, a full act being stayed, to the best of my knowledge, either never happens or happens extremely rarely. Under our constitutional articles also, for example, Article 13, you only, in the interim or finally, stay or stop or nullify that part or that degree which is offensive. It is not a blanket bull in a china shop approach by any court, but that's legalistic. The funny part of some very eminent greases on your, not your, but on channels across, which displayed a blissful ignorance of law was that I, in particular, as one of the lead counsel, specifically argued, as did many others, that nobody is seeking a stay of the act. It is like setting up a straw man and then after judgment shooting it down triumphantly. No such straw man existed. Who asked for a stay of the act? Please ask all the senior counsel appearing.
Okay.
So this is absolutely almost a, were it not a great tragedy of miscommunication, it would be comic. Why should you want to stay of the whole act? There are various offensive provisions of the act according to the petitioners. According to them, they are the major irritants on the ground in reality. You were considering as the apex court an interim arrangement. You are not deciding it finally. So as an interim arrangement, you will only touch upon those things which are more of an irritant till such time as you can hear the matter finally. In the interim, indeed, even finally, either the act is quashed, but in the interim, nobody stays the whole act. So therefore, we only asked for those major irritants, and as I will go down the program with you,
Okay.
I believe we got 70 to 80% of the major irritants stayed. There were one or two setbacks, very candidly. An interim order, on the whole, balanced in the favor of protecting the petitioner's rights. And I'll go one by one and tell you how.
Okay. Dr. Singhvi, Waqf by user. Let's look at that. Because it was one of the major contentious parts of this amendment. You in court had argued that this concept has been judicially recognized even by the Supreme Court in the Ram Janambhoomi temple case. However, the Supreme Court accepted the fears of misuse and declared that the deletion is not arbitrary, given that the Solicitor General had assured that the deletion shall only be prospective in nature. Are you then satisfied with this observation?
No. You're absolutely right. In the 70% to 80% positive bag of the interim order, the balance 20%, I would say the biggest part which I'm disappointed with is the Waqf by user part. There are other peripheral issues which are not really serious on the ground. What was serious on the ground, which we have not succeeded in the interim, as you rightly put it, is Waqf by user. Now, the reason I'm disappointed is because in the case of Waqf by user, which I specifically argued at great length, there is very respectable lineage of case authority prior, not only the Ayodhya Rama Janambhoomi, but Ayodhya Ram Janambhoomi itself cites 100-year-old cases which say that this is a concept in Islam recognized as a customary situation for decades and for many half centuries. Now that having got a court ratification in earlier judgments could well have been a basis for giving an interim order of stay. Now the court in its wisdom has not done it. It still falls in the 20 to 25% bag of disappointments. You win some, you lose some. You have to respect the court in the 80% which we've won in. This would have been very important for me, but of course it has not been done. I think it will lead to some chaos on the ground. A large number, the numbers were given in the proceedings, hundreds and thousands. In fact, sometimes they say even the majority of Waqfs are by user because they don't have formal documentation. They are not formally declared, but they've been accepted all along. So that may create some problem, but that's the way it is. There are a lot of other safeguards of ours, ground realities and irritants which have been accepted.
Okay, Dr. Singhvi, since you speak about those 70 to 80%, would you say that an important part of the judgment in which the court is, in its direction has said, will not prevent the parties from making submissions with regard to the validity of the provisions contained in the amended Waqf Act or any of the provisions therein? Do you see this as a win for you, and this will be part of those 70-80 safeguards that you're looking at?
Well, let me just itemize them very briefly without being technical for your audience. One of the major ones, very major ones was, which I had specifically pressed and argued, this thing about disqualifying somebody on the basis that he's not a 5-year practicing Muslim. We had pointed out several scare scenarios, an impossibility of determination, an impossibility of criteria fairly applied to decide. How do I come into your bedroom or drawing room and prove that you are or you're not a Muslim? You go by rumor, by innuendo, by insinuation, by arbitrariness, etc., etc. All that has been accepted by basically saying that 5 years will not be uh, acted upon. And remember, this is an interim order unless and until requisite rules and details are given. Of course, when the rules come and the details come, if they are themselves arbitrary or nonsensical or whimsical, they can again be challenged. But as of now, there are no ways, criteria to determine it, and the court has therefore rightfully stated. So that's a major victory. The second major victory is that uh, you had an entire set of, I don't want to bore you with details, in fact, 3 provisions, which said that you will cease to recognize you as a Waqf, while I, a government officer, undergoes the process of determining details about you. So this was putting the cart before the horse, we said. This was a result before adjudication, and that too by government officers. That entire fasciculus of 3 provisions has been stayed. Basically now, till a adjudicatory or a quasi-judicial determination is made, you cannot, in the interim, in the meanwhile, cease to recognize you as a Waqf while you go about the process of determining your status. So this is a major victory. Another third major victory is, in fact, fundamental. The character of Waqfs had been changed intrinsically by having clearly, as we demonstrated, a majority in the boards and the council of non-Muslims. If they so choose to appoint, the power was there. It has now been specified that there has to be a Muslim majority in the council. Indeed, they've gone further and said that although the provision is not clear, the CEO and the secretary would have to be Muslims as well. It's another major victory. Now, there are, of course, issues. For example, Ancient Monuments Act issue. For example, this Limitation Act application. A more important example, registration of Waqfs. I personally believe they are not dispositive or serious in any manner for our contentions. They are relatively more peripheral. Of course, one would like, different council argued different points. One would like all these points to have succeeded, but they did not, but they are very peripheral. The heart of the matter is only the points I have told you, plus the Waqf by user, where we were unsuccessful, which is why I say it's an 80% plus bag of reasonably good, balanced interim order, which removes the serious misgivings on the ground in many, many examples, but does not do so in a few.
And Dr. Singhvi, since you speak about the non-Muslim members, are you then satisfied with the cap declared, as the court did point out, in fact, the Supreme Court pointed out ambiguity in the upper limit of number of non-Muslim inclusion?
That provision is very unhappily drafted. Again, I don't want to get into technicalities. That provision is very unhappily drafted. In fact, it is so weird that you don't know whether it's talking of a minimum or a maximum. It's almost impossible to draft such a crazy kind of provision. But be that as it may, the bottom line was that you cannot, as we give a list of some 10 Hindu institutions, from the famous Tirupati through Jagannath temples, all the other temples. We said it would be inconceivable that a place of religion so cherished by the Hindu community could have non-Hindus, for example, on the board, in a majority, in a controlling sense. And the court ultimately accepted that the basic running should be in the hands of the Muslim community members. And that's a fair point. This applies to Christians as well. It applies to Sikhs as well. Can you imagine a Gurdwara with a majority of Christians or Hindus running it? So therefore, I think it's a very simple point. It should never have been in the Act in the first place, by the way. The Act I submit, and this I will argue at some length in the final hearing, is mischievously designed on these provisions to somehow bring in through the back door a majority of non-Muslims. That's not fair, that's not right. But be that as it may, for the time being, remember this is all an interim order, it's not a final decision. Every point which either I have been successful in or I have been unsuccessful in, which I put as an 80-20 ratio, will be available for arguments by both sides in the final hearing.
Okay.
So you might get a quashing of Waqf by user, or you might get something against ourselves in the other points.
Okay. And Dr. Singhvi, one of the points which have gone in your favor, in the favor of the petitioners, is Section 3C2. Courts state this clause, and now a Waqf property doesn't need to wait for a government officer's report before being treated as Waqf? How does it help your cause?
That's the point I made already, no? When I said there is a fasciculus of 3 provisions, that provision you read goes along with 2 others. The court has put it here if you want me to tell you. It's the provisions are 3C, 3
Yes, sir.
and 3C2.
Yes.
And they're all quoted in the order.
Yes.
The combined effect of this was, Marya, before it was stayed, that while you go about the process of dealing with the Waqf status, identity, validity, etc., during that period, you need not recognize its status as a Waqf at all. So this is a very ridiculous thing. It's like putting the cart before the horse. Before the adjudicatory determination is over by a neutral judicial or semi-judicial umpire, the officer is entitled not to treat it as a Waqf at all. This is one of the major things which has been stayed. All these provisions, related provisions, have been stayed. This is the point I made earlier. And let me also digress for 15 seconds. In another canard going along, and again, I think it's very sad and sorry that some eminent people are speaking about it. It displays a complete ignorance of law, a blissful and a happy ignorance of law. That look, Supreme Court has interfered with the parliamentary law. Supreme Court cannot interfere with the parliamentary law. I mean, were it not coming from some eminent person, it would be laughable. Very briefly, number 1, we are a proud democracy with judicial review in our country exceeding anywhere else by any other apex court on planet Earth. Number 2, daily, every day, because we have a constitution, acts of parliament are struck down completely on final hearing, completely rendered null and void on the lack of constitutionality, on the anvil of not being in harmony with the constitution. So what is so great about a court declaring a provision invalid or in the interim staying it? Thirdly, actually, we have more than this. Unlike 90% of the countries of the world, even if you pass a constitutional amendment tomorrow, which for any reason violates the basic structure features, even a constitutional amendment can be held to be unconstitutional. With this kind of powers of judicial review, it's a very sorry and sad state that I found many of the programs across the day in the country, which I was reported to, saying that, look, how can the Supreme Court interfere in a parliamentary law? It sounds funny, actually, but it's not tragic.
All right, Dr. Singhvi, appreciate your time. Thank you for joining us and decoding this order. Of course, as you say, that this is an interim order, and you see this as an 80% success for the petitioners. Let me bring in our second newsmaker now. Joining us is Jagdambika Pal, who is a BJP MP and also the chairman of the Joint Parliamentary Committee on the Waqf Amendment Bill. Jagdambika Pal, as the chairman of the JPC on Waqf Amendment Bill, how do you respond to this partial stay and the court's concerns on procedural safeguards?
It is not a partial stay. It is only for the time being. Honorable Supreme Court has taken some view and observation, either you can say verdict. Okay, now, till the state should formulate the rules for the practicing of 5 years Islam. It is only for the time being. And now, whatever today's Supreme Court has given this verdict, it is absolutely a victory of a parliamentary democracy, because the piece of legislation on Waqf Amendment Act was just comes through the JPC. JPC did a lot of exercise for the last 6 months. We took 36 meetings also, and exhaustive for on an average 7-8 hours every day. The opposition, they are charging that we have not given an opportunity in front of JPC. I think so. They have given adequate time, at least for 6, 7, 8 hours. You have seen in all the 36 meetings, they were all present. If sometimes any tensions, some towards things been happen, even after half an hour, again the meeting has been resumed now. And even not only we took meeting 36 at Delhi only, we have taken extensive tour throughout the country. Today I'm in Bhubaneswar, even Bhubaneswar, Calcutta, Guwahati, Ahmedabad, Mumbai, Hyderabad, Bengaluru. There, the whole entire Joint Parliamentary Committee met with a lot of stakeholders, All India Muslim Personal Law Board, SIA Board, Sunni Waqf Board, and And even in Parliament on the floor of the House, I should say in the history of the Parliament, for the first time more than 14 hours, 15 hours, the discussion takes place on the floor of the House on this particular bill in Lok Sabha also and Rajya Sabha also. So after due diligence and this exhaustive participation of debate from opposition also, I'm very thankful. The entire opposition, they have participated also and they have endorsed the view. So after due deliberations and discussions and exhaustive, then this bill was enacted from both the houses. So now today what Supreme Court has given a decision, it is endorsed, it is a stamp on that constitutional act. So certainly it is a victory of parliamentary democracy, it is a victory of the power and strength of the legislature also.
जगदम्बिका पाल जी, आप इसको अपनी विक्ट्री देखते हैं, पेटिशनर्स भी इसको अपनी विक्ट्री देख रहे हैं, क्योंकि if I'm looking at number of tweets which have been put out by various Congress leaders, they are of the opinion that the collector will not decide whether a property is Waqf or not. Another provision where they see a success is that the CEO of the board must be a Muslim. In the state Waqf board, no more than 3 members can be from any other religion. In the central Waqf board, no more than 4 members. And again, there is a provision of, there is a stay on the condition that a property can be made Waqf only if the person has been a Muslim for 5 years. Is this then some setback? Because there are certain, some kind of balancing which has been done here in this interim order.
Not the least, because they are telling a lie. They were deadly opposing that why any non-Muslim should be included either in state Waqf board, either in National Minority Commission, because they gave a lot of examples for some endowment also, some even, I think so, religious board also. So then categorically our department, Ministry of Minority and even officers also, and even I have said, now Waqf board is not a religious body. Minority Commission is not a religious body. Waqf board is a statutory body where the officers, they have been appointed to look after the Waqf property. So then I think so if any institution is a statutory body, there should be appointment from the non-Muslims also, because it is only for the administrative purposes. So they were against the not even a single Muslim, but today Supreme Court has given the verdict that at least 3 non-Muslims can be appointed in a state Waqf board and 4 they can be appointed in National Minority Commissions. So certainly whatever we have raised are concerned, I think so that has been endorsed, and that was even in bill also, and it was endorsed by the Supreme Court also. Only they are only just, I think so, misleading to the nations. What number of suggestions even in our joint parliamentary committee we accepted. We have made 14 recommendations, and government is very kind enough. Our recommendations they have accepted also, and then amended bill was just enacted on the table of the House, and it was passed from Lok Sabha and Rajya Sabha after a detailed deliberations and discussions also, and a lot of the things.
Jagdambika Pal, the Supreme Court expressed concern over the provisions giving government officials the power to decide on Waqf property disputes, because staying some of these powers. How do you then respond to the court's emphasis on separation of powers and its implications for the Act?
There is only, I agreed also, there is a separation of power. But in today, what Supreme Court has said, that is only mentioned about the separation of power, not separation of substance. And here it is only separation of substance. In districts, who is the custodian of the land? Either government land, private land, farmers' land. I think so. Collector is not an individual. Collector is not a man of someone. Either government, whoever so today, either we may be in governance, tomorrow somebody may be else, other party also. But now a permanent organ, only district magistrate, he is a custodian of all the records of the lands. If any dispute arises somewhere, so only on the basis of the record of the collectorate only I think so any decision can be taken by the judiciary also. So far, there is no power. If anybody is aggrieved, suppose that your land has been declared as a work property, and in any case, if you are aggrieved, only you can go to the tribunal. And tribunal, if gives adverse any decision, so you can't move, you can't file any appeal in High Court and Supreme Court. I think so. Article 300A, what provides? Article 300A provides you anybody, a citizen of the country, if he owns his own property, if he is aggrieved, he can go to the High Court, he can go to the Supreme Court also. So in 2013, Congress UPA government had just, I think so, did this right. Now in this present Amendment Act, now anyone can go to the High Court and Supreme Court to protect his own land.
All right, Jagdambika Pal, Chairman of the Joint Parliamentary Committee on Waqf, thank you for joining us and sharing your views on the interim order of the Supreme Court on the Waqf Amendment Act. We are putting out that entire interview on our website. That's all from me on this edition of the News Track. I'll be seeing you tomorrow. Thanks so much for watching.